Any mention?
I beg to mention item number 7, my lord. This matter, my lord, we need to file a rejoinder to the affidavit filed by the state, my lord. I'm praying for another 3 weeks' time, my lord.
Your Lordship, I am hearing this matter on behalf of the state.
7.
My lord, it's on hearing list, my lord.
Dr. A. Saraf.
My lord.
But it's only argued this matter, correct?
No, my lord, this is a different matter, my lord.
I thought this matter was argued part heard or something. No.
No, my lord.
What's the matter
Your
about?
Lordship, there was a previous round of litigation for the refund of the mineral cess that had been collected under the Meghalaya Mineral Cess Act. It is our case that this is barred by res judicata because a previous prayer of the same nature was rejected.
The time bar
This matter is not
by delay.
My lord.
it was rejected on merits by
On merits.
the bench of this. Yes, on merits. Now they've come up again in a similar petition asking for an identical prayer. Counter has been filed, rejoinder perhaps has not been filed.
My lord.
It was on the hearing list. Okay. On the prayer of MS Abdatta, counsel petitioner. How much times?
3 weeks.
How much time? 3 weeks time allowed for joint list thereafter and so on. Yes.
May it please Lordship, I beg to mention item number 8. Due to some personal difficulties of the senior conducting
Who's for the
counsel,
other side?
I have informed the Master Borwa yesterday, Your
You
Lordship.
inform the other side.
Yes, Your Lordship.
After?
I think he's the joining through
May
VC.
please, Your Lordship. May please.
Yes, you are appearing.
May
Mr.
please,
Bora.
Your Lordship.
Yes.
I am appearing. Yes, Lordship. I am appearing. Lordship, I am appearing for the bank. It's a matter regarding compassionate appointment. Lordship wanted to, learned senior counsel wanted to oppose reply, and it was part heard on the last occasion, Lordship. Therefore, Lordship, I just pray to fix a date after June 20.
When?
After 3 weeks, Your Lordship.
Okay, 3 weeks. They'll give the date, yes.
Highly obliged.
On the prayer of so the matter stands adjourned to so.
Supplementary list item number 1.
My Lord, we are challenging the impugned order dated, my Lord, 22/12/2022, Annexure 5, page 30, my Lord.
22.
My Lord. Now, my Lord, the genesis of challenging this order, my Lord, goes back
Which page is it?
page 30, my Lord.
31.
30, my Lord, 30. Annexure 5.
Order section 33. Yes.
My Lord. My Lord, this order is in consequence to a show cause notice which was dated 39/2022, my Lord, Annexure 4, page 25.
Okay.
Now, my Lord, I am a 70-year-old woman, my Lord, with comorbidities and age-old related ailments. My Lord, I was the proprietor of a firm by the name and style of, my Lord, Hanuman Baksh Umadat, my Lord, Annexure 1, page 17.
Lecture 1, yes.
My Lord. My Lord, after the coming of the GST regime, my Lord, my firm was registered under the GST portal as on 1/7/2017. My Lord, my business was being run by my agents, my employees, as I am of age. And my Lord, post that, my Lord, somewhere around 3rd of September 2021, page 20, Annexure 2, my Lord, type copy is at page 22.
Yes, what happened?
My Lord, I entered into an agreement to sell my business to a person known to me along with the business premises. My Lord, this agreement for sale, my Lord, we had entered into was on 3rd of September 2021, and my Lord, by 31st of March 2022, we had completed the formalities. And from 1st of April 2022, my Lord, with the new financial year coming into, the business was transferred to the new proprietor. Now, my Lord, accordingly, My lord, annexure 3, page 24.
Yes.
My lord, wide an order which was dated 24/1/2023, my lord. My lord, here the dates take effect.
20, page 24.
Page 24, annexure 3. My lord, bottom left below the...
11/22.
My lord, that is the date from which the order will take effect. If my lord sees below the table on the left hand side, my lord,
Yes,
24/1/23.
Yeah.
And my lord, third line on top, my lord, the effect date of cancellation of your registration is 9/11/2022, my lord. So, my lord, on 1st of April 2022, I have handed over my business. Accordingly, my GST registration gets cancelled, while the order dated 24/1/23 taking effect from 9/11/22. Now, my lord, post this, my firm has been diluted, the registration has been cancelled, there is no business I am running. Now, my lord, suddenly in the month of April 2025, my son gets an intimation call from one of the recovery officers from the Department of GST, my lord, saying that I have certain debts which are to be recovered. My lord, not understanding through our accountant, we try to find out, and that is when we come to know that, my lord, page 25, annexure 4,
Show cause have been.
show cause was issued to me, my lord.
Yes.
My lord, it is the same office who has cancelled my GST registration in the annexure, previous annexure, my lord, where there is no outstanding tax liability which he has shown in the table appended thereto. Now, my lord, this show cause notice was never physically made over to me. My lord, it will be their case, and I do not dispute that they said that it was uploaded in my GST portal and subsequently sent to one of the registered emails, my lord. Now, my lord, once my firm was cancelled, my GST registration was cancelled almost 9 months prior to issuance of the show cause notice, and while cancellation they had categorically stated that I have no outstanding liabilities. Now, my lord, there was no way for me to come to know that this particular notice was issued to me for enabling me to reply to the same. My lord, annexure 5.
Let's see what's your GSTN number? Is the same one. This is
My lord.
17 AB. Where is that? Where's your
My lord, annexure 3, page 24.
yes, where's the GSTN?
My lord, where the order of cancellation is addressed to me,
Yes.
it is there, my lord. There is no dispute to it. That was my firm, which was subsequently I had sold, and then my GST registration was cancelled.
Yes.
So, my lord, my case here is limited, my lord. I do not at this moment dispute,
Have any knowledge about?
my lord, the notice which was issued to me. My lord, my humble prayer is that I may be given an opportunity to reply to this notice, my lord, because it is my stand that I have a case where the applicability of this
What's the
recovery,
period of appeal from the orders, final orders?
my lord, 90 days, but that is long gone, my lord. So the notice was never made over to me. Now, my lord, my case is that since my GST registration was cancelled and that cancellation certificate itself came with no tax liability, so there was no way for me to go on checking that portal or coming to, and my lord, I am a senior citizen of age. So,
Yes, Mr. Sinkan.
My lord, if my lord will come to page number 25 of the petition. My lord, this is the show cause notice. What it transpires, my lord, the case is...
Financial year 17-18.
My lord, 17-18, yes. It is pertaining to the ITC claim for the year 17-18, my lord, financial year.
Where is final? Last date?
Last date of claiming ITC for the financial year 17-18 is 24/2019. So, I need further instruction, my lord. However, my lord, as per the record which is available, it transpires, my lord, that they have claimed the ITC, my lord, beyond the prescribed period, my lord.
The input tax credit.
Right. They have availed that benefit, my lord.
my lord, for that, my lord, page 36.
Let them come up with instructions.
My lord. My lord,
Meanwhile, we will.
there is a notification from the government which specifically says that the period has been extended. My lord, page 36, entry 5. If I may, my lord.
Notwithstanding.
My lord, notwithstanding anything contained in subsection 4, this is subsection 4 of section 16, in respect of an invoice for debit note for supply of goods or services or both pertaining to the financial year 17-18, 18-19, 19-20 and 20-21, the registered person shall be entitled to take tax input credit in any return under section 39 which is filed up to the 13th day of November 21. So, my lord, their show cause notice speaks of April, but there is an extension given by the department itself. Now, my lord, my case is not on the merit over here with regards to the show cause. I want an opportunity to go and present my case before the authorities. As on date, my lord,
Instructions, yes.
Let me get instruction.
my lord, in the meantime, no coercive action be taken because they will freeze my account for recovery, my lord.
You heard Mr. N. Kera, the counsel of petitioner.
My lord, let us get the instruction, my
No,
lord. There
let them
should not
take
be any-
my lord, no coercive action be taken, otherwise
Issue
my
notice, Mr.
petition becomes
N.
infructuous.
Sincon is present. Who's for Union of India? MSR Gurung, Vice Dr. N. Musica, DSCI is present. Accept notice on behalf of respondent number 1. Mr. N. Sincon is present and accept notice on behalf of respondents number 2 and 3. As such, no further notice called. Stop. The prayer writ petitioner. Or the petitioner hearings agreed with an ex parte order
My lord,
dated
22/12/23, my lord.
22/12/2023 passed by the respondent number 2. That's for number 3, whereby the petitioner, where's the impugn order?
My lord, Annexure 5, page 30.
From now?
My lord, page 30 of 31, bottom of the table, my lord, they mention that recovery proceedings will be initiated.
Under section 73 of the what is this called, Meghalaya GST?
MGST, yes, my lord.
It was MGST, whereby the petitioner is directed to make a payment of what amount?
My lord, the principal was 14,22,592 with penalty, interest and tax, my lord. It comes to 30,17,778.
30,17,078 inclusive of
778.
interest and penalty by 22/1/2024, in which recovery proceedings would be initiated. Stop. Like for submitted Ms. N. Kera that this petitioner was unaware about the proceedings in as much as far back as on when 21.
My lord, 2020, 22 first April, it was 21. It was sold.
From 1/4/2022, the management and proprietorship of the firm in question had vested with new proprietors. He submits that the GSTN UIN of the petitioner having been cancelled, they were not apprehensive that any proceedings would lie against them any further. So he prays that he submits that the limited prayer of the petitioner is to allow her to file a statutory appeal against the order, but however, as the order is dated 20.
My lord, I want to first go and give a reply to the show cause which was given.
Whatever, he wants to file appeal or show cause, wants show cause for reply to the, wants to file appeal or show cause to the show cause notice. Stop. Inasmuch and as the same has been is barred by limitation, this writ appeal has been preferred. So he further prays that in the interim that no coercive, no recovery proceedings be initiated against the petitioner while the matter is pending before this court. Next para Ms. N. Sincon, learned GA have paid for 1, 2 and 3. Prays that he may be allowed to obtain requisite instructions before the next date and submits that no interim orders are called for at this stage. Next para upon hearing, let counsel for the parties and also presumably to the court. It is noted that it is a fact that the GS, what is that? Is that annexure?
My lord, cancellation.
GSTIN license or number of the which have been cancelled on 9/11/22.
My lord, 24/1/23 it was cancelled with effect from 9/11/22.
Yeah, but however, the show cause notice, it can be seen relates to the last date for claiming input tax credits for the financial year 2017-18. It could be that it may, as matters seized by the court after the next date, no coercive action of recovery shall be taken to the petitioner. List on?
2 weeks, my lord, after
Just after 2 weeks also.
obliged.
Highly obliged, my lord.
Daily list item number 1.
My lord, I am entering appearance for the sole respondent, my lord. So let this matter come up, my lord, after 2 weeks, my lord, by admission.
Mr. S. D. today has entered appearance on behalf
The sole
of the
respondent.
sole respondent. As such, it is complete. He prays that the matter be listed after 2 weeks.
After 2 weeks, my lord.
Not objected to by MS. E. Varsali, counsel for the appellant. It is after 2 weeks for admission here.
My lord.
Item number 2.
May it please your lordships. My lord, if your lordships will recall, on the last date, my learned friend had on instructions submitted that the revised returns can be filed by taking recourse to section 139(8)(a). And my lords, we were to avail instructions on this matter, whether we can actually take recourse to 8A.
But,
My lords will-
but you submitted last time, there's no question of filing physical returns.
Yes, my lords. It was their instruction that we can file it online by taking recourse to 8A, because 8A now the period is 48 months, and we are well within 48 months. Now we were uncertain whether 8A is actually applicable. If may I just satisfy, my lords, please have the Income Tax Act, the relevant provision, my lords. Section 139. And so section 139 relates to filing of return of income. So broadly, there are about 3 types of returns that are to be filed. One is the original return that is filed by an assessee.
139?
Section 139.
No. What provision Mr. Pandey said last time?
He had referred to 8A.
139(8)(a), lordship.
Okay.
So my case, Melon, there's a marked difference between a revised return and an updated return. 8A relates to an updated return.
8 capital A.
8 capital A.
Any person,
Yes, my lord.
whether or not he has furnished a
Whether or
return.
not he has furnished a return under subsection 1 or subsection 4 or subsection 5. Now, let's subsection 5 relates to filing of a revised return. So, I just give a lot of a quick backdrop. So, there are broadly 3 types of returns that can be filed under 139. First is a normal original return that a person files, any SSE files. Now, in case he discovers any omission or any mistake in his original returns, then he can invoke subsection 5 and file a revised return. And in case he underreports his income, then he can take recourse to 8A. I'll just show you, lordships, the language of subsection 5 minutes. If your lordships will first have subsection 5.
What is your problem? You wanted to file revised return.
Revised return, my lord.
Yes.
So, and that is also the direction of the ITAT. Now, the problem with the revised return is I don't have this option available in the portal. Now, as per their instructions, we should take recourse to 8A. 8A does not cater to a situation where I'm seeking to underreport. Let's kindly see. 8A, any person, whether or not he has furnished a return under subsection 1 or subsection 4 or subsection 5 for an assessment year, hereinafter referred to as the relevant assessment year, may furnish an updated return of his income or the income of any person in respect of which he is assessable under this act for the previous year relevant to such assessment year, in the prescribed form, verified in such manner and setting forth such particulars as may be prescribed at any time within, now it is 48 months with effect from 2025, from the end of the relevant assessment year, provided that the provision of this subsection shall not apply if the updated return A is a return of a loss or has the effect of decreasing the total tax liability determined on the basis of return furnished under subsection 1 or subsection 4 or subsection 5. My case falls under B. In case I now file a revised return, it will result in decreasing the total tax liability. Similarly, if your lordships look at
So you
the,
say that it will not cover you.
it will not
But
cover me.
proviso excludes you.
Yes, my lord. And also see the third proviso, my lord.
Results in refund.
Provided also that no updated return, the third proviso,
Yes.
shall be furnished by any person for the relevant assessment year where, and kindly see B, any proceeding for assessment or reassessment or recomputation or revision of income under this section is pending or has been completed for the relevant assessment year. In my case, it was already complete.
So then now filing of fiscal returns, how is it facilitated? Suppose it is necessary, doesn't come within under contemplation of 8A. What is it? What do income tax authorities do in such a situation?
Lordship, as per my understanding, instruction, Lordship, there is absolutely no provision for filing of physical return, Lordship, as of now, Lordship, under the provisions of Income Tax Act. I think this is a very unique situation, Lordship.
Unique case, if he says that yes, he has the effect of decreased rule, and so the question of refund will come also.
Yes, my lord.
Lordship,
That is my instruction.
Lordship.
Because I have already paid advance tax.
Then,
Lordship, only things that section, like my learned friend rightly pointed out, Lordship, I think the provision for filing revised return comes under section 139(5), Lordship. And 139(8)(a), as I understand, Lordship, now that it will not cover the
so
case,
what should he
Lordship.
do then?
So, my lords, they may be directed to accept my physical return and comply with it and consider it in terms of the directions of the ITAT.
Let him take instructions again. Yes, in the last date of hearing, the learned counsel for the income tax authorities, Mr. S. had submitted that the petitioner could file his revised returns under section 139 bracket 8 capital A and instead of capital A. Today, Mr. SN has submitted that the said provision would have no application to the case of petitioner in view of the operation of 8A, 8 capital A, small b.
That's the first proviso.
First proviso, there is first proviso B, which states that the subsection, this subsection will apply if the updated return has the effect of decreasing the total tax liability, which is the case of the petitioner. Paragraph. In this view of the matter, Mr. S. Pandey prays that he may be allowed to obtain further instructions as to whether the petitioner may be permitted to file a fiscal return before the income authorities. Yes, list after
A week's time, my lord.
a physical revised return. Yes, huh?
Revised return, Lordship.
Yes.
A week's time, my lord.
1 week. He'll get his list after 1 week.
Obliged.
Most obliged, Lordship.
Item number 3.
Please, Lordship. Your Lordship, today I'm praying for some adjournment in this matter. If this matter could come up. Your Lordship, this is an criminal appeal. There's a missed case, Your Lordship, for seeking leave of this honorable court for preferring an appeal. So we have filed a missed case.
Why Meghalaya called Apex Bank? What is the...
Your Lordship, this appeal is preferred against the judgment of the judgment and order dated 14/11, which is passed by the learned CJM at William Nagar, being GR case number 21 of 2018, which was similarly upheld by the district and session judge.
Why you want accommodation today on delay?
Your Lordship, there's some bereavement in the family of the arguing counsel, Shri Vicky Jindal.
Yes, due to the bereavement in the family of the arguing counsel, list the matter after
2 weeks more.
2 weeks.
Yes.
Any mention?
His Lordship, I beg to mention item number 30, my lord, for the private respondent. For hearing, I have informed the Lordship.
Your objection?
No.
Yes, 2 weeks.
Lordship.
No urgency? No urgency?
No urgency. Much for less, Lordship.
Yes.
Please, Lordship. Your Lordship, I beg to mention item number 21.
Yes.
Lordship, I'm praying for 2 weeks' time.
You're for?
I'm for respondent number 9, Lordship. Private respondent.
You mentioned on behalf of number 9. Yes, no objective, not objective to
No
by
objection.
2 weeks, yes. Yes.
I'm praying if this matter can be fixed on 19th, Lordship.
Oh, July?
19 June.
Requested by
19 June, Your Lordship.
Why? What's so special 19 June?
Take up this matter, Lordship.
See, the thing is that, Mr. Chanda, fixing dates have no meaning. When the dates are fixed, someone has difficulty. They'll come for 2 weeks.
Obliged, Lordship.
2 weeks will be around that time only.
Obliged, Lordship.
Yes, make it quick.
Please, Your Lordship, I beg to mention item number 33.
33?
Yes, sir. That will come after 2 weeks, sir.
MPSC, Lordship.
Yes?
MPSC.
Is that
appointment of APP, Your
matter?
Lordship, yes.
You are interested in pursuing the matter? Is the petition interested?
Yes, Your Lordship.
He has not challenged the appointment, correct?
No, Your Lordship. We are only aggrieved by the
you challenge only the
notification, Your Lordship, but we are only aggrieved by the category of unreserved category, Your Lordship.
But then you already been appointed, correct?
Yes, he has been appointed, Your Lordship.
Your representative is incompetent now.
I will have to take instructions.
Yota praised that we have 2 weeks time to take instructions. Take instructions, otherwise there's no point in just keeping a case that this. Yes.
Apply.
Much obliged, Your Lordship. Lordship, I beg to mention item number 28 and 29. 28 and 29, Your Lordship. Connected matters. On behalf of S. Pandey, Your Lordship.
What will happen to Mr. Pandey?
Actually, Your Lordship, have to seek instruction. The petition has just been recently transferred from.
For instruction 28, 29?
Lordship, 27, 28, 29 are tagged together.
Yes, sir. Yeah, Mr.
S.A. Majao.
Majao?
Yes, Your Lordship. S.A. Majao.
Mr. S. Majao, 100% praise that you allowed 2 weeks time to obtain instructions. Stop on 28, 29, 22 weeks granted. Next, on 27, Mr. Upadhyay submits that as this matter is linked with item 28, 29 placed today, listed together next date. Yes. Yes.
Hello.
Yes, Mr. Lasangloya.
I beg to mention item number 31, Your Lordship. Lordship, on the last occasion, Your Lordship had directed me to take fresh steps on the respondent number 8.
Number?
On the private respondent, Your Lordship. Respondent number 8.
Respondent number 8 is whom?
She's a terminated teacher, Your Lordship. However,
You've taken steps.
Yes, Lordship. However, service has not been affected. Service has not been affected, Your Lordship.
We'll just take a submission. We hope it's correct. It's correct, yes, Mr. Lasangloya. Learned counsel for the petition submits that steps have since been taken on the.
There is a order, Your Lordship. On the last date, there is a order that
take steps.
for taking steps.
He prays we allowed 2 weeks time to obtain status report.
In the meanwhile, I'll be able to file my affidavit of service.
No, you obtain whether you've been served or not. You are free to file this.
Obliged, Your
Yes.
Lordship.
Much obliged.
Yes.
Your Lordship. Lordship, I beg to mention item number 22. I pray for 2 weeks' time. Since
Why?
the conducting counsel is not keeping well.
You can argue it.
I'm not the one who's purpose of this case.
Yes.
Yes, Your Lordship. No
You're there.
objection.
In the matter.
Actually, Your Lordship, I am not there.
Your name's
But
not there in the list.
I'm not there, Your Lordship. But under instruction, I am appearing on behalf of Mr.
There are
Arjival.
1, 2, 3, 4, 5, 6, 7 government advocates listed here, but Indian not there.
RG Gurung is the conducting counsel here. Your Lordship,
What's
22.
Arkolni doing? He's also conducting counsel here.
Just I was informed to.
ER Khan, H. Kharmi, S. Sham, SN. Yes, after 2 weeks, it's on the play.
Supplementary list, item number 1.
You please, Your Lordship. This is Section 11 application under the Arbitration and Conciliation Act for appointment of arbitrator.
Section 11. Yes, arbitration clause is there.
My lords. My lords would find it at page 28, my lords. My lords. Typed copy is at page, next page, my lords would find the typed copy. I'm sorry, my lords. 28B, my lords would find 70.
Yes. Yes.
It appears that the claim was expressly
They say, my lords, that it is time barred.
I'll file an affidavit.
When was the contract completed?
Well, its contract was completed way back in 2010, 2012. 12.
That means you should have filed in 2015.
No, my lords, thereafter what happened is we filed the bills. The first application was made by us, my lords, in 2020. They responded, my lords, saying that our claim is time barred, my lords, in 2022. So the period, my lords, would, my humble submission.
12 is over.
My lords.
Your bills were cleared when?
Bills have not been cleared, my lords. That's where the dispute
lords, you can listen.
What is it become? I hope it's not a stale claim.
Well, they say it's a stale claim, my lords.
Okay.
Page 84, my lord, subpara B below, my lord.
Another 3 years, yes.
3 years, my lords. 137 is not disputed, but I am saying that the cause of action would arise on the day on which they refuse my claim.
Assisted by Ms. S. Chanda for the petitioner, Dr. N. Muzika, Leonard DSI with so-and-so present accept notice on behalf of
all the
respondents called for just after 2 weeks for instructions or affidavit.
Can I grant 3 weeks time?
Yes?
3 weeks time.
3 weeks.
3 weeks. Highly obliged.
Item number 2.
Yes. Yes.
Lordship, this case is for non-compliance of judgment and order dated 18 February 2025, Your Lordship.
What does the order say? Where's the operative part in the order? Page?
Annexure P1, Your Lordship.
Page?
Page number 25.
Operative part?
25, Your Lordship.
25. What does it say? Before appeal for judgment order of single judgment, so we like appellants return the seized gold. Okay, they have not returned the seized gold within.
No,
Make it clear within 4 weeks.
4 weeks.
So when did you communicate the order? You communicated it on 28th March. So 28th April was gone. They received it on 28th March only. So 4 weeks is 4 weeks. Yes. Heard your name?
P. Harmotion.
P. Harmotion.
Yes, Your Lordship.
Heard MSP Harmotion. Issue notice as to why contempt proceedings were drawn up against the respondents for violation of the order dated 18/2/2025, passed with appeal number 20/2024, whereby in the last paragraph the division bench, while upholding the order of single judge, had directed the respondents herein to return the seized gold to the respondent 4 weeks of the conviction order. Stop. This after steps were taken within 3 days, just after 2 weeks, yes.
Highly obliged, Lordship.
Item number 3.
This is a contempt matter, my lord, where my lord's order has not been complied with. They have challenged my lord's order before the division bench, but division bench has uphold the order of this single bench, my lord. Page 34, my lord. Page 34, my lord, is the relevant portion of the judgment which they have violated.
34. Relevant part of the judgment.
The relevant part is in page 45, my lord.
Heard, Mr.
The respondent should, the last paragraph, my lord, the respondent should be deemed to have resigned as a regular employee and treated as voluntary retirement. From the above, I affirm that the impugned judgment and order dated so and so, the said judgment and order shall be complied with within 8 weeks, my lord.
Yes,
now, after this, my lord, we have issued them a notice, my lord, and this was received on 18/3, the next page, my lord, it is page 46. 18/3/2025.
Heard Mr. SD has
We'll take steps,
to notice
take steps
as to why contempt proceedings have run up against the respondents 1 and 2 for violation of order dated 12/3/2025, wherein directions have been passed 25 passed in with appeal number 39/2024, wherein while upholding the order of the single judge, it has been directed respondents to treat the resignation.
Yes, my lord.
Of the petitioner as voluntarily retired. Is submitted and steps taken 3 days. This after 2 weeks.
Item number 4.
How long will it take?
It's take about half an hour, 40 minutes.
Okay,
I have to deal with my learned friends' arguments.
On maintainability. So one point which which struck my mind after that is that the BCCI case. See, when it came to segregating the sort of cause of actions, if this action, certain action of a body involves public function, like in the term selection of teams and so on and so forth, then it's a public function. But others, no.
No, man.
Yeah, so you have to.
I would fall in the first category.
You have to confine your arguments. Like,
I would fall.
If we take,
I would fall in the first category.
If we take the help of that BCCI judgment.
BCCI and Bini, which my learned friend had made a passing reference. He did not place the judgment. I'll place it. Bini clarifies this entire position as to what would constitute a public function. Under what circumstances it would be a public function.
We have to limit it on maintainability to that.
On that issue, and of course the other issue raised by a friend about alternative remedy, arbitration.
But Pram Pasai, maybe we're not affiliated anymore. Then yes, I call other matters first.
Daily list item number 1.
Adjourn this matter.
Lordship, we're filing the list which you lodged.
You filed it?
We'll file it.
Where's the list?
These are the proposed names.
Yes.
On the last occasion, Your Lordship had indicated that perhaps somebody else also from the
Yatra.
Anyway,
we've given this list. Your Lordship may consider it.
As per the directions of this court, dated 7/5/2025, a list, fresh list of proposed names for consideration for reconstitution of the committee has been furnished by the learned Assistant Advocate General. A copy of the same is taken on board and made part of the records. However, due to the absence of the British Council due to bereavement, they found this a matter after
2 weeks more.
2 weeks.
Right,
you give copy to him.
I have
received.
Furnished you.
Item number 2.
Yes.
Right, please, Your Lordship. Your Lordship, may the matter be adjourned for 3 weeks as the conducting counsel is.
Are you opposing it?
No. Well, this is that matter where your lordships had heard us on the 711 application filed by the respondents. Of course, my lords, it's been quite a while since that matter was argued.
But why you think adjournments repeatedly?
Due to personal difficulties, Your Lordship.
You're not, still interested, the petitioner.
Well, he wants to pursue this matter, my lords. This is one of those matters where he's still interested, apparently, to pursue the matter.
Just on principle or looking for desired result?
I am unable to respond.
Yes, application for adjournment is filed by the respondent. The same respondent due to the unavailability of the conducting counsel today. For the reasons in adjournment application, matter stands adjourned to 2 weeks.
3 weeks, Your Lordship.
That'll be 2 weeks. Yes.
This would, again, my lords, a very interesting question of law arises there. Because they say non-compliance of section 80 and 81. Your lordships have already delivered some judgments in the other matters.
Yes.
We'll try and assist your
We're
lordship.
already taking evidence in other matter also.
Item number 3.
By name we're withdrawing.
No, he's directed publication of...
We have to. Have we done it?
Gazetted notification. Yeah. Yes, so you've seen the Gazette notification?
Well, it's
notice.
We have not been.
Yeah.
We have not been favoured with a copy.
So this is just a notice actually. No, this is because that's a process one.
That has to be.
Then we'll notify it. Yes.
Yeah.
You'll have to pay. You'll have to pay cost. Oh.
Well, I think these things, well, it's when election matters are withdrawn, as your lordships had rightly indicated in the last matter, puts us in a very difficult.
You have any objection to withdrawal?
We don't have any objection.
No objection.
No objection.
No further claims. Except Mr. Nongburi, you have some.
Except, yes.
For the election commission to permit us to remove the
yes.
EVMs.
That interim order, just point out. No? There was an interim order passed by this court.
Kindly, yes.
I'll just assist your lordships. This is the one. This one. Show me. Well, it's this is the order dated 18/7/2023, which was passed in miscellaneous application number 16 of 2023.
Okay, 1811.
Knowledge.
In miss case number?
16 of 2023.
11/23 in 16/11 23. Then we'll pass orders. Yes. Instead of pass it. Then you don't have any objections.
No, that order can be vacated, but
yes, you have to be vacated. Yes.
Highly obliged.
Item number 4.
Miss case number bro.
Service incomplete.
Where's Mr. Azarika?
Petitioner is absent, Your Lordship.
And appears for petition list after 2 weeks.
Apply, Your Lordship.
Apply.
5.
Please, Lordship. Lordship, we filed the affidavit in this matter.
When do you file it?
This morning, Lordship.
Your Lordship, we've just received copies. Your Lordship, if Your Lordship can kindly grant us...
Hearing today.
Your Lordship, 2 weeks, Your Lordship will decide, Your Lordship, whether rejoinder will be
2
required
weeks.
or not.
We'll listen after 1 week.
Your Lordship.
You take instructions, yes. Affidavit has since been filed in item number 11.
5 to 11.
PC number 331.
5 to 11, Lordship.
5 to
We'll be relying on same affidavit, Lordship.
331, 2024. In 330, sorry. Yeah, 30. Stop Mr. H. Karwanlang, learned additional senior advocate, submits that this affidavit will suffice for the other to answer the other petitions which are similarly situated. Stop. MSDF Mauri, Learned Counsel for the respondent.
Your Lordship, I'm the petitioner, Your Lordship.
Sorry, for the petitioner.
In items
Raise 1
number
week's
12.
time to obtain instructions as to whether rejoin is necessary. Similar payment by MS Bisun on behalf of
Item 5 to 11, Your Lordship.
5 to 11 years. Just after 1 week.
I do oblige.
16.
Please, Your Lordship. Lordship, this is a pension matter, my lord. We have received the affidavit filed by the respondents, my lord. It can be posted for your hearing, my lord. We will not be filing a rejoinder.
Yes, Mr. Movements raised the matter to hearing. Yes.
Lordship, hello, my lord.
Yes, on
17.
AG Movement does the counsel petitioner submits that no rejoinder will be necessary. Raise the matter to hearing. Yes.
May it please Your Lordship. Your Lordship, in this matter, I have filed an application for impleadment.
Been allowed?
No, my lord, it has not been allowed. I have just filed.
Where's the other side?
My lord, it's Miss Case number 88, my lord.
Yes, there, Mr. Rana. Any objection?
Lordship, this matter, Mr. Adaya Sangma is.
Who's Mr.?
Adaya, Lordship. Lordship, he is in hospital at the moment.
He was here that day, back to hospital.
Lordship, yesterday he called me, he was not well.
Yes, due to the absence of the conducting counsel on behalf of the respondents, this application together the main case on tomorrow. Not tomorrow, next week.
Lordship.
Highly obliged, my lord.
Highly obliged.
18.
What?
Your Lordship, I had
filed
filed.
application
Yes,
challenging
Your
the
Lordship.
same.
Yes, Your Lordship.
Where's the application? This case?
Your Lordship, Miss Case number 89 of 2025.
Yes. Where's Mr. D?
Lordship, can you list this matter up next week because we
Why?
need to seek proper instruction, Lordship.
Your Lordship, we are allowed to file the objection to this application. We'll file it,
Yes,
Lordship.
Miss Case 89, 2025. Huh? This application has been filed for stay or notification dated 10/4/2025, issued by the respondents number. AGDC respondents number? 1 and 2. So, Mr. P.T. Sama for the respondent number 4 and 5.
Right. Said that 4 and 5. Yes, I'm praying for
objection.
Yes.
And so and so for response 1, 2, 3. Please allow 1 week time of instruction. Just after 1 week.
Lordship. Lordship. God bless, Lordship.
19.
May it please Your Lordship. Your Lordship, I'm praying for 2 weeks' time.
Where's Mr. Sen? He didn't come to court.
Stay, Your Lordship.
And waiting time file affidavit.
We yet to receive instructions.
When
Your
did you
Lordship.
file this matter, Mr. President? It's in April.
In May, Your Lordship.
Oh, then yes, for the 2 weeks time they allowed for affidavit.
20.
Please, Lordship. For respondent number 2 to 19, Lordship, can you be allowed us to file a counter
You've
affidavit?
got copy of the writ petition?
Yes, Lordship.
Yes, sir.
What's the matter about?
It is regarding that risk purchase, my lord. But they have sought to invoke risk purchases
Yeah,
against me.
Which department?
Sale, Lordship. Sale.
Oh,
Sale
still,
authority.
yes. Okay. Yes, Mr. Kharakar, Third Counsel for 229. What about 19? What about you, Mr. Dr. Mozika? You want to file affidavit? Praise the Lord. How much time?
Lordship, 3 weeks' time may be allowed.
3 weeks' time.
Chips.
3 weeks time to file affidavit. Prayers allowed. Next line, Dr. N. Mozika submits that as they just, for number 1, as they just formal parties, no affidavit before coming from this respondent.
It's an interim order.
Interim order is there?
Yes.
Interim order, if any, shall continue till next date.
All right.
Second call, item number 4, supplementary list.
So your stand is that it's not an arbitrable dispute. It is not an arbitrable dispute. Number 1, that the alternate remedy will not is not efficacious, and number 2 is public function. This is things.
Well, let's first deal with the issue of public function.
Yes.
Now, well, it's my friend had placed BCCI yesterday. If we can just go back to BCCI, let's. Just give me the compilation.
Page 88 of compilation.
Yeah, let's.
Public function.
176. Paragraph 33 minutes is fallen from my lordships.
Para?
33 minutes.
Yes.
May I just read para 33? It's at page 206 of the compilation.
Yes.
It's the majority view, if my lords have it.
Yesterday was read by...
My learned friend has read it, my lords. The majority view thus favours the view that BCCI is amenable to the writ jurisdiction of the High Court under Article 226, even when it is not state within the meaning of Article 12. The rationale underlying the view, if we may say, with utmost respect, lies in the nature of duties and functions which BCCI performs. It is common ground that the respondent board has a complete sway over the game of cricket in this country. It regulates and controls the game to the exclusion of all others. It formulates rules, regulations, norms and standards covering all aspects of the game. It enjoys the power of choosing the members of the national team and the umpires. It exercises the powers of disqualifying players, which may at times put an end to the sporting career of a person. It spends crores of rupees on building and maintaining infrastructure like stadia, running of cricket academies and supporting state associations. It frames pension schemes and incurs expenditure on coaches, trainers, etc. It sells broadcast and telecast rights and collects admission fee to venues where matches are played. All these activities are undertaken with the tacit concurrence of the state government and the government of India, who are not only fully aware but supportive of the activities of the board. The state has not chosen to bring any law or taken away any other step that would either deprive or dilute the board's monopoly in the field of cricket. On the contrary, the government of India has allowed the board to select the national team, which is then recognized by all concerned and applauded by the entire nation, including at times by the highest of the dignitaries when they win tournaments and bring laurels home. Those distinguishing themselves in the international arena are conferred with the highest civilian awards like Bharat Ratna, Padma Vibhushan, Padma Bhushan, and the passion for this game in this country. The cricketers are seen as icons, as youngsters, middle-aged and old alike. Any organization or entity that has such pervasive control over the game and its affairs and such powers as can make dreams end up in smoke and come true cannot be said to be undertaking any private activity. Then they say, Millards, para 34, the functions of the board are clearly public functions which till such time the state intervenes and to take over the same remain in the nature of public functions, no matter discharged by a society registered under the Registration of Societies Act. Suffice it to say that if the government not only allows an autonomous private body to discharge functions which it could in law take over or regulate, but even lends its assistance to such a non-government body to undertake such functions which by their very nature are public functions, it cannot be said that the functions are not public functions, or that the entity discharging the same is not answerable on the standards generally applicable to judicial review of state action. Our answer to the question, therefore, is in the negative qua the first part and affirmative qua the second part. It may not be state under Article 12 of the Constitution, but certainly amenable to jurisdiction under Article 226 of the Constitution. In so far as IGU is concerned, it falls on equal footfall, in so far as BCCI is concerned. They're exactly set in the same place. It regulates the game. It controls how the game is promoted and played in India. It selects the national team. It represents India in various international tournaments, including the Olympics. Because if a team is to be sent to the Olympics, it's recommended by the IGU. And without IGU, I cannot go anywhere. Now the question therefore comes, and what was sought to be argued before my lords yesterday, is that very well that I may be a public body, amenable to jurisdiction, but I have two sets of functions. One may be in the realm of private public functions, one may be in the realm of private matters, which I am then dealing with. Now, for that, we would have to understand what is the role of the state association. As I submitted yesterday, there is a federal structure.
Right.
In the federal structure, what happens is, we have IGU on top, and below IGU, we have the state associations. Now, IGU on its own, cannot recommend players or have teams or have state level games or national level games, without the state associations being there. Because what happens is, for any national level game, the state association has to then, from the clubs who are affiliate members of the state association, then recommend that certain players would be representing the state insofar as the national tournaments are concerned. So in all fairness, both these bodies are actually discharging public functions, even though they may be registered bodies under the Societies Registration Act. Now, the very fact, that it is an apex body of golf in the country requires of such body to act with all fairness. That's fundamental.
Yes.
To that extent, what would be public function, I will place Bini, the case of Bini. This is 2005 6 SCC, page 657. This is Bini versus V. Sadashivan. I just place the judgment.
Here the compilation, no?
No, it's not in the compilation. I'll give it. Compilation. Copy for the court. Give a copy. You have it. Give it a book. I take your lordships to paragraph 11 and 29, My lords would find paragraph 11 at page 665. There was reference to this judgment in all the judgments, that were referred by my friend yesterday, because this decides the issue. If my lords kindly have page 665, paragraph 11.
Yeah, judicial review.
Judicial review is designed to prevent the cases of abuse of power and neglect of duty by public authorities. However, under our Constitution, Article 226 is couched in such a way that a writ of mandamus could be issued even against a private authority. However, such private authority must be discharging a public function, and the decision sought to be corrected or enforced must be in discharge of a public function. The role of the state expanded enormously, and attempts have been made to create various agencies to perform the governmental functions. Several corporations and companies have also been formed by the government to run industries and to carry on trading activities. These have come to be known as public sector undertakings. However, in the interpretation given to Article 12 of the Constitution, this court took the view that many of these companies and corporations could come within the sweep of Article 12 of the Constitution. At the same time, there are private bodies also which may be discharging public functions. it is difficult to draw a line between public functions and private functions where they are being discharged by a purely private authority. A body is performing a public function when it seeks to achieve some collective benefit for the public or a section of the public and is accepted by the public or that section of the public as having authority to do so. Well, I would place emphasis on these lines. AMLs, that it performs a certain function. Now, that function, my lords, may be for the benefit of the society at large or a section of the society. Now, it's not only the question of them performing that function, my lords, the section of society or the society must accept that as final and binding. That is the test.
That they have authority to do so.
Yes.
That it has authority and we
so, and it is final.
Yes.
So once they say that, my lords, that matter becomes final, then it becomes a public function. Once that test is met, my lords,
yes,
then there cannot be any dispute as to whether it is a public function or a private function. It purely comes within the zone of public function. In this case, my lords, there is no dispute that IGU is the apex body. There is also no dispute, my lords, that IGU is formed only with the sole purpose of regulating and promoting golf in India. And, my lords, all bodies, all clubs, all associations, all players are subject to the final decision of my lords, the golf union. So, both the tests are met. One, they can take a decision. Two, that decision has to be accepted by everybody or that section of society. Once that happens, my lords, it is definitely within the realm of public function.
Okay.
So, my humble submission would be, my lords, this particular paragraph of Bini essentially settles this matter in my favor. Now, something very interesting, my lords, in the course of digging up came up yesterday. There's something called. Give me this. Do you have copies of this? No, for the other side. Well, lords, there is this compendium of executive instructions which are issued from time to time by the Ministry of Youth and Sports Affairs, Youth Affairs and Sports, by the Government of India, my lords, regulating all sports in the country. Now, this is called the National Sports Development Code of India, 2011.
National Sports
Development Code of India, 2011.
Okay.
Now, this is a comprehensive code, my lords. It contains all the guidelines that have been issued from time to time.
Any bearing on this?
Yes, my lords, it does. Because it specifically says. Now, what has happened in 2010, and probably this aspect of the matter has never been brought on record in any of the proceedings before any court. What happened, my lords, in 2010, the Government of India issued a notification under the RTI Act. All NSWs, my lords, they are called NFWs, National Federal Societies, my lords, which regulate sport in various disciplines, were brought within the purview of as public authorities under the RTI Act.
Okay.
For the court master. Copies for them.
I mean, state bodies.
State bodies. The national federations, my lords.
Oh, sorry. Yes. National federations.
Now, this is very interesting, my lords. If my lords kindly have a look at it.
Yes.
My lords, there are these two letters. The first is dated the 21st of April 2010. It says, my lords, declaring national sports federations as public authority regarding. I am directed to refer to your department's letter of even number so-and-so on the subject of declaring all national sports federations receiving grant of rupees 10 lakhs or more as public authority under Section 2H of the Right to Information Act. The NSFs were requested to designate the Central Public Information Officers and appellate authorities as per Section 5 of the RTI Act and also to fulfill other obligations. In response, the Ministry, in receipt of letters of some NSFs seeking extension of time for compliance of these instructions, taking this request into consideration, it has now been decided to extend the time limit. My lords, this is extension of time limit. The original notification is on the earlier page. My lords, might kindly see 30th March 2010.
Yes.
It is the President Secretaries of all national sports federations declaring national sports federations as public authority. On receiving directions from the Central Information Commission to identify, notify and direct all NGOs, other organizations falling within the purview of the Ministry of Youth Affairs and Sports and qualifying as public authority under the Right to Information Act, the ministry undertook an exercise in respect of national sports federations to check the applicability of various conditions in the RTI Act and noted that national sports federations come within the purview of the Ministry of Youth Affairs and Sports as per the allocation of business rules 1961. The ministry recognizes one national level sports federation in each discipline for the purposes of development and promotion of their disciplines. These federations are fully responsible and accountable for the overall management, direction, control, regulation, promotion and development of the discipline in the country. They are expected to collaborate with the Ministry of Youth Affairs and Sports Authority of India to develop promotional plans and activities for the development of their discipline. They are in turn recognized by various international federations and also by the Indian Olympics Association. They serve as the nodal body for participation of India teams in international events. They are also responsible for affiliation of state and district units in the country, which where even I come in. They receive special attention and privileges from the government which are otherwise unavailable to such organizations. They receive government funding for various purposes, including organization of national championships and training and participation of sportspersons in tournaments in India and abroad, equipment, coaches and other facilities. The government grants forms major part of the budget for promotion and development of the sport, including preparation of national teams. The government specifies the purpose and manner in which such timing be utilized, such funding be utilized by, and the federations are.
Yes, here also you get funding.
Yes, I'll point out. Their accounts are before your lordships.
Yes.
For the privilege of funding so received, the government, after taking into consideration all the relevant facts and circumstances, has concluded the national sports federations are doing a state function and are dependent on government funding for performing this task and hence are substantially financed by the government. It has therefore been decided to declare all national sports federations receiving grant of rupees 10 lakhs or more as public authority under section 2H of the RTI Act 2005. All NSFs getting covered by the provisions are requested to immediately designate so and so, so and so, so and so. So in this view of this matter, my lords, these are essentially, my lords, bodies which are taking care of a certain discipline of a certain sport. Recognizing this, my lords, the union has now declared them as state functions. They say there's state functions, so you become a public authority and as such you are amenable to the RTI. For them to then turn around and say that, my lords, no, it is, I am a private society and my decisions are not to be questioned in a writ court, my lords, would therefore not lay. Also considering, my lords, that one of the factors that was considered by the central government while doing it is, my lords, what I pointed out at serial Roman 7, that they are responsible for affiliation of state and district units in the country.
Yes.
So this is one of the considerations before the central government, that you also have the objective of affiliating state and district units. So therefore, my lords, this read with Bini, in my humble submission, would be that any action taken by them for affiliation or de-affiliation, my lords, of a state body would be a public function. It cannot be at their whims and fancies.
Okay.
That coupled with the fact, my lords, that once you are an apex body, you are recognized by the government of India for the purposes of, my lords, golf in the country, you cannot escape your liability and say that I may not be amenable to jurisdiction. Especially, my lords, since the power is discretionary, you have to exercise it within the four corners of the rules of natural justice.
Yes. Mr. Jhariso, you've been given a copy of this letter?
I've given a copy.
Receive.
And, my lords, this compendium further goes on. I'll just place this compendium, my lords. I'm sorry, it's such a voluminous document, I could not give my learned friend a copy. But it is their document, my lords. Now, this also says, my lords, about granting recognition. The compendium very specifically deals of how you are giving recognition to state bodies. What happens, my lords, if you are not following the process? To the extent, my lords, the government says that if you are not doing the job properly, we can actually withdraw your affiliation of the National Federation. First, keep it under suspension for an inquiry by the central government. After inquiry, my lords, if it is found, it can be suspended and even withdrawn. So the government has absolute pervasive control insofar as these NSFs are concerned. So any function by these NSFs, my lords, would essentially be a public function, and make them amenable to jurisdiction of this honorable court.
Yes. Hmm.
You can place this for the court. It's flag marked, my lords. I can just place it for my lords' kind perusal.
So you can extract them and make copies.
We'll make extracts and file it, my lords, with copies to my learned friend. My lords.
Yes.
Because this essentially deals with these notifications which have been issued from time to time. Because the government of India has also come up with a sports policy. Under that policy, my lords,
pervasive control. That is one of the tests.
Whether
the government exercises control over.
Now, the question that fell for my lords is whether they are receiving, my lords, any money from the union government. If I may, my lords, if my lords kindly have my rejoinder affidavit. Well, it's Annexure 5, page 21. This is the audited, well, it's financial statements. This is for the financial year ending 31st March 2023. At page 21.
Yes.
If my lords kindly have a look, on the right side, my lords, 1, 2, 3, 4, fourth column is the income.
It's taking so long. Yes.
Fourth column is the income, my lords. And if my lords kindly have 1, 2, 3, 4, 5, 6, 7, 8 grants from government, my lords. So they are receiving grants from government on that particular year, my lords. They received about 11 crores.
7 crores.
I'm sorry, 1 crore 14 lakhs 8,406. Then, my lords, on the other side, if my lords kindly have a look on the expenditure column, the first column, my lords, one entry is highlighted, it is underlined. Your lordships will kindly see financial assistance to SGA.
Where is that?
Well, it's on the column number 1, my lords. I was at column number 4, that is income. Column number 1 is expenditure. The same page, my lords, page 21, same page. First column, my lords, is expenditure. Your lordships will kindly see right on top.
Yes.
Then it is golf development expenses, my lords, is the first heading. Second heading, down below, underlined, is financial assistance to SGA.
Yes.
And there, my lords, your lordships will kindly see that they are paying money to the various state golf associations. My lords.
Yes.
So not only are they getting money from the government, my lords, they are also giving money to the state golf associations. Next page, if my lords kindly have a look. This is again the audited statement, my lords. Again, in liabilities, your lordships will see grant from government. This is 1, 2, 3, 4, 5, 6, 7. Seventh entry from the top.
Yes.
Grants from government.
Yes.
Next page, my lords will kindly see at page 23. Receipt, my lords, against receipts. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 13 lines on top, my lords. Grant from Government of India. My lords have it.
Grant from SAI and grant from. Okay.
It says, my lords, grant from the Government of India. In the next page, my lords, it's more clear. If my lords kindly have a look at page 24. This is for the financial year ending 31st March 2024. Again, receipt, my lords, against receipt. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 lines from the top, my lords, grants from the Government of India. So they've got 13 crores for the financial year, my lords, 2023-2024. So substantial money is actually paid by the Government of India, my lords. They in turn disburse it to the state agencies, state associations. So for all practical purposes, my lords, they are managing even the financials of all these organizations. So therefore, my lords, to then come and say that my relationship with the state association is not something which is within the realm of public function, my lords, would be absolutely misplaced.
Anything else?
Well, in this context, there's a judgment of the Honorable High Court of Manipur, which sits exactly squarely on the facts of this case. I'll just place that, my lords. Copies. Yes, this is 2021 online Manipur 126. This is by the Manipur Fencing Association, my lords. Paragraph 37. My lords, may kindly have a look at paragraph 37, my lords. This deals with this issue of affiliation, de-affiliation. My lords would find it, there's no internal paging, I'm sorry, my lords.
37.
37.
Long paragraph. Yes, got it. Bottom.
So far as the power of disaffiliation is concerned, there can be no dispute that FAI has ample power either under the amended or unamended Memorandum of Association. Such power is indispensable in order to control its members within the bounds of the Memorandum of Association Constitution. The corollary issue is as to what procedure will have to be followed by the FAI before a member is disaffiliated by it. No procedure appears to have been contemplated in its Memorandum of Association, except stating that if the election is not held within the grace period and after the expiry of the tenure, the member will stand automatically disaffiliated. The contention of the Petitioner Association in this regard is that the impugned order has been issued by FAI in violation of the principles of natural justice and without application of mind. The stand of FAI is that despite its various letters, correspondences being addressed to the Petitioner Association, it has failed to comply with the directions, with the result that the Petitioner Association stands disaffiliated and dissolved. In such circumstances, can the need of giving a show cause notice be dispensed with automatically? In other words, are the principles of natural justice not required to be followed by the FAI? From perusal of these letters, correspondences as mentioned in the counter affidavit filed on behalf of the respondent number 1 and 2, it is seen that they are addressed to the Secretary Generals of all the member associations of the states, union territories, requesting them to furnish the documents as mentioned therein. None of these letters, correspondences is addressed to the Petitioner Association specifically informing that if it fails to comply with the direction, it will be disaffiliated by FAI. The Petitioner Association was not given an opportunity to explain why election was not held in time. The FAI did not take any decision after the Petitioner Association being given an opportunity of being heard. The disaffiliation of the Petitioner Association by the FAI without following the principles of natural justice is unreasonable and bad in law, being violative of Article 14 of the Constitution. Squarely sits in my case, my lords, because even in my case, in the affidavit filed before my lords, they say that this has been, the decision to disaffiliate me, my lords, has been preceded by some notice which was sent to me. I had pointed out at Annexure 1 of the counter affidavit filed, my lords, this was a general notice given to all state associations requiring them to file certain documents for the updation of the records of IGU. No other document has been placed before my lords to show that there has been any kind of communication to me informing them of any decision to, my lords, conduct any inquiry against me or for that matter disaffiliate me.
Yes.
We come to that.
Anything else, Mr. Paul? I think that wraps up your submissions.
That is only on that issue of alternative dispute that my lords have already seen that I am, my lords, already.
The thing is that now your submission said there's no arbitrable. It's an arbitrable dispute.
It's not an arbitrable dispute. Why I say it's not an arbitrable dispute, my lords? First, I had said that I am disaffiliated. So the moment I'm disaffiliated, my lords, that clause cannot be binding upon me. That's one.
Yes.
Otherwise, also, my lords, it says the expression used is unresolved dispute. Well, has to
be subsisting.
It has to be a live dispute. Your lordships have, well, Unless it is a live dispute or a subsisting dispute, my lords, where is the question of arbitration? The very fact, my lords, that you did not even raise a dispute. Had they, my lords, questioned me, saying that ABC is not complied and tell me why we should not take action against you, my lords, there would have been a dispute. I would have countered that. That would have given rise to a dispute which could have been unresolved. I do not concede to the fact that clause 66 applies to me. Only for the sake of arguments, my lords, I said that if you had questioned me, I would have refuted that, my lords. That would have given rise to a dispute. If that dispute then needed resolution, probably that argument could have been put into effect that you have to go under arbitration. But here, my lords, there was a unilateral decision and which is actually vitiated by malafide. Your lordships have seen that some gentleman sitting somewhere, my lords, in the month of December 2024, after having, my lords, woken up an organization which was otherwise defunct till 2 years back, decides to say that please give us affiliation. And, my lords, thereafter, the IGU swings into action. They say, my lords, they've sent a team for verification. And, my lords, on the basis of the verification report of the team that had come here, some unilateral order is passed, not only disqualifying me, in the same breath, they affiliate the other organization. It is actuated by malice, if not anything else.
Okay. Yes, Mr. Charles, you reply tomorrow.
Madam, I'll take a short reply.
Because you questioned yesterday.
Yes.
But, my lords, there's one authority on that issue. But I don't think, my lords, any authority is required on this.
Tomorrow.
Yes, so for the hearing tomorrow.
Yes.
You can
Yes.
let her, well, only in that point, which is court was concerned, public function.
Yes.
And that you addressed it, so let them see what they have to say.
Because I was quite surprised, my lords, this notification of 2010 was probably not brought into notice of any of the courts below. Anywhere, my lords, including the Honorable Supreme Court in the BCCI matter.
It says 2005 judgment.
There's one in 2015 as well, my lords.
Yes.
Probably this would have been a clincher. The union should have placed this, my lords. Now it seems that the union government is making an effort to actually regulate all these NSFs, my lords, so that there is some semblance of legality in their actions. Highly obliged.
Tomorrow?
Yes.
We'll file the written argument, sir.
Okay.
If my lords so please, my lords, I have concluded it.
Yes. Only maintainability. So.
That's.
Yes.
Hearing 23.
Thank you.
Yes. Yes, respondents.
Well, the filing affidavit on last occasion, I have not received
Full instructions of that, madam. Matter के कहाँ आपको week or 10 days में?
1 week for a time allowed for receive instructions on the additional affidavit filed by the petitioner.
Petitioner at present.
Yes.
24.
Obliged.
Please, Your Lordship. Your Lordship, as per the last order, the state have to come up with instruction, Your Lordship.
With regard to? Yes, the Council is also got agreement each of his necessary invitement. Going to have no for a grievance. Case obvious matter was heard. Yes. Yes, Mr. Kharon.
Lordship, the government is not inclined to accept the minutes.
The agreement.
Yes, Lordship.
Mr. H. Karan today has submitted that the state respondents are not agreeable to accept the agreement reached for fixation of interest seniority between the vice principals and SDSEOs, which was arrived at a joint meeting dated 18/1/2025. In this next matter, this is a matter of further hearing on.
May please, Lordship.
Yes.
Lordship, a small prayer. If I can file a short affidavit with regards to the minister meeting, Lordship. Lordship, I bring to.
That is the problem to Larry. Agreement. of interest seniority, which was arrived at on so and so. Stop. He further prays he will have to file an additional affidavit.
Bring on record
the yes.
The final integrated seniority list.
The final
integrated seniority list of assistant teachers.
Of the
the assistant teachers of secondary and higher secondary schools.
Of the secondary and higher secondary schools. It lists after 2 weeks. Yes.
3 weeks, Your Lordship.
Why 3 weeks? You can file it when?
Lordship, give me 1 week's time, Lordship.
You do 1 week, then you get a copy, then you it's after 1 week, the order column is
25.
The contempt matter?
Yes, my lord.
Where's the order, Doctor?
Lordship will come to peace.
Where's the operative part?
My lord, Lordship, may kindly come to page 27, my lord. May I read, my lord? May I read, my lord?
Yes.
Lordship, may kindly come to page 28 from para 4, my lord. And appropriately noticed in this impugned judgment, this is the second round of litigation. According to the appellant, it was entitled to benefit under the Transport Subsidy Scheme 1971, which had been formulated and notified for grant of subsidy on the transport of raw materials and finished goods to and from selected areas with a view to promote and growth of industries. There is no dispute that the Meghalaya fell within the selected areas A of the scheme, wherein the appellant has the industry unit. Subsidy for diverse period were disbursed to the appellant upon claims being raised. However, 2 lots of subsidy for the periods October 1, 2008 to December 31st, 2008 and January to March, that means, my lord, for two quarters, respectively, for total principal amount of this one were not disbursed. Indeed, by letter dated September 2, 2014, claims for the such periods were declined on the ground that expenses incurred were in case and payments made in case were not eligible to be considered for the relevant subsidy. The appellant challenged the decision by way of 2 petitions for 2 periods. The relevant period under petitions under 226 of the Constitution were disposed of by holding that claims for subsidy prior to September 10, 2009, even if made in case, were liable to be considered, and claims for any period thereafter, if made in case, would not be eligible to be considered subsidy. However, despite this court holding in relevant order May 3, 2019, that means, my lord, about 6 years back, that the claims for the previous periods, even if disbursed in case, would be considered for grant of subsidy. The relevant petitions were disposed of on the basis of the following operative order. Petitions is disposed of with the direction to the respondent that they shall reconsider the claim of the petitioner in the light of the aforesaid observations for disbursement of the subsidy amounting so and so, respectively, along with interest for the date of pre-audit report, and to pass appropriate order thereon, whatever permissible under the rules for the period of the 4 weeks. That an appeal preferred by the union is to dispose of, since the union repented in appeal that the order impugned in the appeal has already been complied with. Because of the, my lord, the compliance, they have made a statement that is complied with, that it's closed. The legal effect of this court's order, that is, my lord, 3rd May 2019, my lord, that is the previous page, my lord, which attained finality, was that whether or not the claims of the previous periods were on the basis of disbursement made in case, they had to be verified, and if found satisfactory upon verification, the claims had to be honored for the release of subsidy. However, despite such previous order of this court and the union having accepted the same by an order of August 2, 2019, a substantial part of combined claim in excess of 2.33 crore were declined, and only a principal amount of such and such was approved for release. Then my lordship may kindly see the reason for recording the relevant order was that the subsidy claim for during second half of the 2008-9 was significantly higher that was have been paid for the first half of the relevant year. The relevant order further reveals that since some of the payments in respect of the first half of 2008 and 9 had been denied on accounts of cash payment, the same principle ought to apply for the claims in respect of subsequent period. That means when the first period also, my lord, where the cash payments were made, my lord, it's also declined. The subsequent second period or subsequent period also declined, my lord. Clearly, this was contrary to the express findings rendered in the order dated May 3, 2019 in earlier round of writ petitions and which became binding on the parties, including the union, upon union's appeal not being pressed. But though they will file appeal, but it was not pressed, it was attained finality. Whether case, my lord, up to a from the date of notification, my lord, this honorable court held, my lord, that prior to date, my lord, it cannot be retrospectively applied. It was, my lord, is prospectively, my lord. Then lordship may kindly para 10, lordship may come to para 10 of the same, my lord, judgment. The union completely misread the order or at any date acted contrary thereto. But they have acted, my lord, even the, my lord, division bench also, my lord, found that thing that they acted contrary thereto, my lord. The next page, lordship may kindly come. Para 13, lordship may kindly see. Accordingly, the appeals are disposed of and the orders impugned are for documents and other evidence from the appellant. A rational and meaningful verification should be conducted by the union and the entire exercise completed within 8 weeks. In the event any part of the claims to be declined, cogent reasons for such rejection should be furnished. Needless to say that the interest awarded in terms of the Supreme Court order as indicated in the Indian order dated of August 2019 will apply if part of balance claim is not allowed. Then my lordship will kindly come to, in fact, my lord, the next page to 34, that is the earlier order which has been referred to May 3, 2019, my lord. The lordship may come, the impugned, my lord, order, how, my lord, they have acted. This order, my lord, passed by the Joint Secretary, my lord, that order dated 28 March 2024.
This
28 March 2024, lordship may kindly come to page 53. Page 53, my lord.
53.
My lord. Here, my lord, what happened, my lord? Again, my lord, what they did, lordship may kindly come to page 55 here. My lord, third para, my lord, the fourth line. Since no policy allows for approving case components. Page 55, my lord, of the petition, my lord. Third para.
That is evident.
Third para, my lord. It is evident that the email of the appellant that do not want to bring new facts to the department knowledge and only want to push for contempt for not carrying out the compliance of the said order of the Honorable High Court. Since no policy allows for approving case components, verifying those claims based on cash payments, invoices not prudent. But they are finding that, my lord, against the, my lord, High Court judgment, my lord, direction that, my lord, it will be, my lord, so cash payment is, my lord, prior to October 2019, my lord, that the case payment will be allowed, my lord. That High Court, my lord, twice the finding was there. And division bench also said that it was misread and my lord, they acted contrary thereto, my lord, earlier. But in spite of that, my lordship may kindly come to next page, my lord. Page 56.
Okay, they said that here.
They say here, my lord. My lord, again, my lord, they talk about the checklist. That the checklist requires that, my lord, that cash payment, my lord, cannot be accepted, and my lord, checklist has to be accepted. So without checklist, my lord, because it will be operated retrospectively, my lord. Lordship may kindly come to page 57. Also, that the checklist transport subsidy scheme provides for payment of transporters only by check, and that payments made in case are ineligible for encashment. That by notification dated 28 September November 2009, a Department Industrial Police Promotion issued checklist for scrutiny of claims under transport substitution, wherein, as per para 2 category mentioned, all claims arising from the transportation for raw materials and finished products prior to 10/9/2009 will be examined pre-audited as per checklist 44. In view of the above checklist A, notification dated so and so is applicable retrospectively, my lord. Here, my lord, again, my lord, they are sitting over the judgment of the Honorable High Court, my lord. That will be a retrospective, whereas the Honorable High Court said it will be prospective, my lord. So, my lord, therefore, as per point 35 of the checklist Y, the applicable of the case of the petitioner which specifies as following. The bank statement for payment made transport subsidy during period only by check, considering the fact and the appellant company has not complied in time-bound manner instructed by Honorable High Court of Meghalaya and failed to resubmit upon the calling requirement documents supporting evidence as per checklist A, as per checklist but check payment. Dated 28 November 2009 as required under Transport Subsidy Scheme 1971, which is applicable retrospectively. As such, the department have rightly taken a decision as per the instructions issued from time to time by the funding agency, that is Union of India. Hence, after the next page, after detailed deliberations, the department decided that application of Meghalaya feed products for grant of rejected claims under the transport subsidy scheme cannot be accepted, as only payments being reflected in bank statement will be taken into account for transport subsidy claim. As such, no relaxation is to be granted in 44 points checklist, even though the checklist has been imposed with retrospective effect. Now, therefore, the matter of rejected claims of Meghalaya feed products has been examined in accordance with directions of Honorable High Court of Meghalaya, and it is hereby rejected as not permissible. This issue with the approval of the Secretary DPIIT.
Yes.
So, my lord, my respectful submission is that, my lord, once the Honorable High Court twice, my lord, has been, my lord, come to conclusion that, my lord, prior to, my lord, when the checklist was formulated, prior to that, my lord, even if made in case, has to be honored, disbursed. You cannot sit over the matter, my lord, since it can be prospective, my lord. So it was, my lord, elaborately described. My lord, even then thereafter, my lord, they said that no, because I to be operative retrospectively and as such, my lord, you cannot make my lord, disburse the payment which has been made in case. So, my lord, that apart, what happened? This case, in the contempt petition, my lord, the lordship is aware. The joint secretary's order is there, my lord. Joint secretary, my lord, I don't know, my lord, for reason best known to him, my lord, chose not to file affidavit, and he has not filed affidavit before the honorable court in the contempt proceeding, my lord. And contempt proceeding, my lord, and the affidavit is filed by respondent number 3, my lord, who is a director, my lord. My lord, she says that, my lord, he is transferred. My lord, lordship is aware that, my lord, in contempt proceeding, my lord, even if the person is retired, even then also, my lord, he is answerable. But here is a case, my lord, he is transferred to other department, and he cannot, my lord, refrain from his responsibilities that, my lord, he is sitting over the matter. It is, my lord, willful and deliberate disobedience of the Honorable High Court order, my lord. And, my lord, it's, my lord, to be punished. And, my lord, affidavit filed by, my lord, respondent number 3, my lord, if your lordship may kindly take up the affidavit by respondent number 3, my lord. They have categorically, my lord, they have stated that, my lord, they have same thing, it is reiterated that, my lord, retrospectively it is in operation, and, my lord, it cannot be paid. If your lordship is, my lord, says got the affidavit, my lord, filed by respondent number 3. My lord, this is the she has filed affidavit on behalf of all, my lord. 1, 2, 3, and 4. My lord, lordship may kindly come to page 5, my lord, of her affidavit. G. That in compliance of the Honorable High Court order dated 13/10/2023, the department issued the speaking order dated 28 March 2024, which I have just read, my lord, by the Joint Secretary. While considering the fact that the petitioner company had not complied time-bound manner as directed by the High Court of Meghalaya and failed to resubmit upon the calling the required documents and supporting evidence as per checklist A. That means, my lord, check payment. My lord, if I have not made check payment, my lord, we did not made check, my lord, wherefrom I will, my lord, submit those issues, my lord, because these are the issues which are when you would not before me, not before them, my lord. In fact, my lord, here is the case in total, my lord. Those are, I am not going to contempt proceeding, my lord. In fact, the fact remains the total, my lord, claimed it was audited by them, my lord, and my lord, they said that, my lord, only check payment will be considered, and they paid it. And other cash payment, my lord, they said we are not going to pay because it will operate retrospectively, my lord, which is against the Honorable High Court order finding, my lord, by single judge and revision bench as well, my lord. Notification dated so and so dated 20th November 2009 as required and transport substance which is applicable retrospectively. Again, my lord, they said it is retrospectively. As such, the department have rightly taken the decision as per the direction instructions issued from time to time for funding agency of the Union of India. Then Lord may kindly come to next page. My lord, that further there is no arbitrariness on the part of the answering respondent as the distance for refusal of the subsidy claim being made in case was rightly rejected as already stated in preliminary submissions. Then, my lord, may kindly come to page 7. All claims arising from transportation of raw materials and finished goods prior to 10/9/2009 will be examined period as per checklist 44 points. In view of the above checklist A, notification number so and so dated 20th November 2009 is applicable retrospectively. Therefore, as per point 35 of checklist A is applicable in case of petitioner which specifies the following: bank statement for payment made to transporter during the period payment only by check. So, my lord, then, my lord, here in fact, my lord, by stating that, my lord, she has my lord, respondent 3, my lord, she is director, my lord, she has reiterated that, my lord, they have acted correctly because according to them, my lord, the notification, my lord, which requires, my lord, payment by check, it operates retrospectively, my lord. Whereas, my lord, the Honorable High Court earlier, my lord, May 2019 as well as 2023, my lord, division bench against which, my lord, contempt is filed, my lord. That Honorable High Court says, my lord, is not, it will not operate retrospectively, to operate prospectively, and what all payments made by case, my lord, has to be made payment. So whatever they paid, my lord, they paid only, my lord, check payment, and cash payment they, my lord, rejected. And my lord, is admittedly the period is March 2009, whereas the notification, my lord, it came in November 2009. So, my lord, about 6 months thereafter, my lord. So, my lord, how can, my lord, retrospectively it can be operated, my lord? So, my lord, here, my lord, my respect submission is that, my lord, they have willfully and deliberately, my lord, disobeyed the Honorable High Court order and sitting over the, my lord, the judgment passed by, my lord, by the Honorable High Court, my lord, and they are duty bound, my lord, to make payment in case, whichever paid in case, and which have been audited, already audited, my lord, should be made paid case, whatever they left out, and while along the interest which, my lord, already Honorable High Court has held, and earlier also they paid. So this is my respect submission in brief, my lord, and this is the this short case, my lord. So, my lord, taken out, my lord, absorb the responsibility, and my lord, and in this case, my lord, personal appearance is, my lord, required, my lord. In fact, my lord, how they can, my lord, sit over the judgment, two judgment. My lord, Honorable High Court division bench said that they misread and acted contrary, my lord. This, my lord, observations already been, my lord, clear terms, words, my lord, is Honorable High Court has said, my lord, despite the fact. But I don't know, my lord, why they are sitting on the matter, my lord, and my lord, he has not filed affidavit also, chose to not file affidavit.
Dr. Mozika?
File affidavit on behalf of respondent 3.
What about this 1 and 2?
Well, we stated in our affidavit that one is in transferred and one is supervision. Well, I'll come to that, my lord, but before that, my lord, my learned senior is referred to the order passed by the division bench, my lord. Now, that was an appeal against an order passed by this honorable court, my lord. So that is not on record. I'll just place that order, my lord. This is where the things originate, my lord.
Yes.
So, my lord, this is order dated 7/8/23 and passed in WPC 345 and 346. By this order, my lord, I'll just take your lordship to the operative part, which is at page
In this compilation, page 45, my lord.
Your compilation.
This is in fact the memo of appeal that was filed before the division bench.
Yes.
Well, I'll read from para 12 onwards, my lord. While examining the action of the respondent number 1, this court cannot ignore a basic fact that when claims are made for reimbursement based on cash transactions, sufficient materials to substantiate the claim are necessary to be provided, which would not be required if payments are made through bank transaction. The notification dated 2011-2009, therefore, as submitted by the respondents, was introduced to discourage such cash transactions, as the source and flow of such transactions could not be easily ascertained or tracked, thereby leading to a detrimental impact on the economy. In the opinion of this court, in this scenario, therefore, the burden of substantiating the claim made on the basis of cash transactions would squarely lie upon the writ petitioner, subject to verification thereof by the claim by the respondents. The respondent, therefore, on not being satisfied with the clearance of the state level committee of the claim as well as the pre-audit report, on being permitted by this court, had by the re-verification exercise reconsidered and allowed payment by the impugned order to the extent they deemed admissible. This court in these circumstances, therefore, while sitting in writ jurisdiction, cannot and is not in a position to render any conclusive finding on the claim of the petitioner, as surely this will fall within the realm of disputed facts which have to be proven. The question, therefore, of determining the legitimate dues of the petitioner by this court, or to endorse the claim as made and to direct for payment as claimed for which a mandamus is sought at this stage, is well nigh possible. In view of the matter, therefore, these writ petitions are closed and disposed of, leaving the writ petitioner to take recourse to appropriate civil proceedings for the reliefs claimed if so advised. So against this order, my lord, they went on appeal, and I'll read, it's a short order, my lord, the appellate order. And what is the context of the appellate order, my lord? Page 24, my lord, 27 of the contempt petition, my lord. May I read, my lord?
Yes.
I'll read from the beginning, my lord. This is the 3 or 4 pages, but this clarify things. In view of the good grounds shown, the delay of about 35 days preparing the appeal is condoned. The appeals are taken up for immediate consideration. The appeals are directed against the judgment order of August 8, 23, by which the appellants writ petitions in respect of the claims for 2 distinct periods on account of transport subsidy were relegated to a suit. As appropriately noticed in the impugned judgment, this is the second round of litigation. According to the appellant, it was entitled to the benefit under the Transport Subsidy Scheme 1971, which had been formulated and notified for grant of subsidy on the transport of raw material and finished goods to and from selected areas with a view to promote the growth of industry. There is no dispute that Meghalaya fell within the selected A area of the scheme, wherein the appellant has an industrial unit. Subsidy for diverse periods were disbursed to the appellant upon claims being raised. However, 2 lots of subsidy for the periods October 1, 2008 to December 31st, 2008 and January 1, 2009 to March 31st, 2009 respectively, for a total principal amount of 2 crores so and so, were not disbursed. Indeed, by a letter dated September 2, 2014, the claims for such periods were declined on the ground that the expenses incurred were in cash and payment made in cash were not eligible to be considered for the relevant subsidy. The appellant challenged the decision by way of 2 petitions for the 2 different periods. The relevant petitions under Article 226 of the Constitution were disposed of by holding that claims for subsidy prior to September 2009, even if made in cash, were liable to be considered, and claims for any period thereafter, if made in cash, would not be eligible to be considered for subsidy. However, despite this court holding in the relevant order of May 3, 2019, that claims made for the previous period, even if they disbursed in cash, would be considered for grant of subsidy, the relevant petitions were disposed of on the basis of the following operative parts. Petition is disposed of with a direction to the respondent that they shall reconsider the claim of the petitioner in the light of the aforesaid observation. But this is order passed by Justice Mir Maloo in 2019. Disbursement of subsidy amounting to rupees 94 lakh and 1 crore 38 lakh so and so for the period so and so, respectively, along with interest from the date of pre-audit report, and to pass appropriate orders thereon, whatever permissible under rules within a period of 4 weeks. An appeal preferred by the union stood disposed of, since the union represented in the appeal that the order impugned in the appeal had already been complied with. The legal effect of this court's order, which attained finality, was that whether or not the claims of the previous periods were on the basis of disbursements made in cash, they had to be verified, and if found satisfactory upon verification,
The claims had to be honored for the release of the subsidy. However, despite such previous order of this court and the union having accepted the same by an order of August 2, 2019, a substantial part of the combined claim in excess of rupees 2.33 crore was declined and only a principal amount of rupees 1.98 was approved for release. The reason recorded in the relevant order was that the subsidy claim during the second half of 2008-9 was significantly higher than what had been paid for the first half of the relevant year. The relevant order further reveals that since some of the payments in respect of the first half of 2008-9 had been denied on account of cash payment, the same principle ought to apply for the claims in respect of the subsequent period. Clearly, this was contrary to the express findings rendered in order of May 3, 2019 in the early round of writ petition, and which became binding on the parties, including the union, upon union's appeal not being pressed. In effect, what the order of May 3, 2019 required was for the union to re-verify the basis of the claim for the two periods, and at such time of verification, if the appellant could establish that the disbursement as claimed had been made, the requisite subsidy should be released. It was open to the court to provide for the subsidy as claimed to be released. However, since the court, in exercise of its authority under 226 of the Constitution, did not enter into the veracity of the claim, it required the union to reconsider its provision in the light of the observation in the relevant order and re-verify the claims of the subsidy for the two period and release the permissible amount within a specified time. The union completely misread the order, or at any rate acted contrary hereto. Notwithstanding the fact that union failed to exercise the task that was required by its previous order of May 3, 2019, and the union rejecting substantial part of the claim on account of payments having been disbursed in case of the appellant in the second round of litigation, the writ court was again not in a position to satisfy itself that the entirety of the claim made for the two periods was genuine. This is because writ petitions are heard on affidavit evidence and oral or other documentary evidences are generally not received. This was the basis for the writ court relegating the appellant's claim to the civil forum for the appellant to affirmatively establish that the disbursements as claimed had been made for the appellant to be entitled to receive the requisite subsidy. In appeal, there is very little that can be done at this stage, since evidence cannot be received for this court to be satisfied that the entirety of the claims made for the two periods were actually disbursed for the appellants to be entitled to such amounts. However, such exercise can be conducted by the union. In fact, the previous order of this court of May 3, 2019 obliged the union to conduct such exercise, which the union failed to undertake.
Okay, now you see that the exercise was conducted and found it under.
Now, I'll just read two paragraphs. Accordingly, the appeals are disposed of and the orders impugned are not modified by directing the respondents to re-verify the rejected part of the claim for those two periods by calling the documents and other evidence from the appellant. So this was the direction, my lord. A rational and meaningful verification should be conducted by the union and the entire exercise completed within 8 weeks from the date. In the event any part of the claim is declined, cogent reasons for so this I can skip, my lord. Para 14 is important now, ma'am. In the event that any part of the balance claim is disallowed, it will be open to the appellant to institute an appropriate action before a civil forum for such part of the claim.
So relegates them to civil court.
But the division bench also relegates them to civil court, my lord. That was what done by your lordship also, my lord. So in my humble submission, my lord, in view of this, my lord, no contempt is made out, my lord. They were given ample remedy by way of approaching the civil court, my lord.
Come back to the order read by Dr. Turi Gangji, 20th March 24, correct?
Well. Now, my lord, may I just refer to a few annexes of my affidavit, my lord?
You file affidavit only behalf of 1 of 3 only.
Yes, my lord. My lord, I have stated, may I just refer to para 1 of this affidavit, my lord? That I am serving, I am skipping this sentence, my lord. The last sentence, the deponent humbly begs to state the respondent number 1, Sri Rajesh Kumar Singh, Secretary, Department for Promotion of Industry,
We have stated that.
has been appointed as officer on special duty, Department of Defence, Ministry of so and so.
We have stated that.
Para 1 of my affidavit, my lord.
This is by Sher Singh Meena.
Dr. Kajal, my lord. Which one is filed later? It is filed in November 24.
Yes. I'm serving Director Minister of Commerce.
My lord. Then the last sentence, my lord. The deponent humbly begs to state that the respondent number 1, Sri Rajesh Kumar Singh, Secretary, Department of Promotion of Industry and Internal Trade, has been appointed as special on official duty, Department of Defense, Ministry of Defense, so and so. And respondent number 2, Sri Balamurugan D, Joint Secretary, Department for Promotion of so and so, has been appointed as Joint Secretary of Ministry of Corporate Affairs by DOPT order number so and so. Further, the respondent number 4, Sri Ganesh H. Nikhare, Under Secretary to the Government of India, Department of so and so, has retired on 31/7/24. Therefore, the respondent number 1, 2, and 4 had been transferred, retired, and Department for Promotion so and so. I have received a copy of the so and so. So this is filed by respondent number 3, my lord. This affidavit. So, my lord, I was just referring to few annexes in this, my lord.
I think we're short of time because this court has to rise with proof inspection at 1 o'clock also.
My lord.
I think Dr. Todi, anything else to add?
My lord, in fact, my lord, my learned friend, my lord, whatever, my lord, is citing, my lord, in fact, my lord, they have said, my lord, that cogent reason has to be given. My cogent reason is that, my lord, that not prudent, my lord, not wise, not judicious, my lord, because it is made with case, payment is made with case, my lord, verifying those documents.
The contempt jurisdiction.
Contempt portion, my lord, he is going, my lord, the original things, my lord. Contempt is, my lord, whether the, my lord, the judgment passed, whether complied or not complied, my lord. And, my lord, disobedience is willful or, my lord, deliberate is that lordship will kindly see, my lord. Now, my lord, there is no scope to go back to the, my lord, main issues where, my lord, my learned friend is going. Only my lordship will kindly see whether the order passed by the Honorable High Court Division Bench, my lord, has been complied or not, my lord. Whether they willful or deliberate disobedience, my lord. So, my lord, as per their, my lord, specifically they have said, my lord, since they made in case, my lord, it is, my lord, not prudent, my lord. That's why prudent, my lord, what I understand, which not wise, judicious, and sensible, my lord. And, my lord, the court said that since it has been rejected, it operates retrospective, my lord. When, my lord, the Honorable Division Bench says that, my lord, is earlier to raise that they have acted contrary thereto, that earlier 3rd May 2019, my lord, order, my lord. Again, they said it to retrospective, my lord. So, my lord, what can be a better case than this is contempt case, my lord? This is a clear case of contempt, my lord, which, my lord, they have, my lord, applied their mind not to act deliberately, sitting over the matter passed by the Honorable High Court, my lord. So, my lord, this is contempt. They have no, my lord, way, my lord, either to comply with. They should have to comply, my lord, whatever the case payment made, which is verified, my lord, they should make payment case.
Tomorrow, doctor, you don't have to be here. You're here, let them place his.
Lordship will like to take tomorrow, my lord.
We'll take tomorrow.
Yes, ma'am.
Just for furthering tomorrow.
26.
Obviously, madam.
My please, your lordship.
Yes.
As per your lordship last order, I was directed to seek instruction whether petitioner can be accommodated. Again, your lordship, I got instruction.
Shall be accommodated.
There is no vacancy as submitted by the petitioner. Lordship may kindly have a look at the instruction.
What to do? mercy petition also you're not willing to consider. What to do?
Your Lordship, as per us, I'll just would like to make some more submission, Your Lordship. As per our knowledge, which has been instructed to us, given to us, there are four posts of typists. The one which the petitioner was officiating, that person has been promoted to
I see
LDA.
the letter she's given you copy.
Yes,
Yeah,
already
I got
given
that, but
the-
then there's no specification. I mean, a clear specification on that will help us, Your Lordship.
Where is this one born? Why?
No, Your Lord. Pardon, Your Lordship.
Where is this post lying vacant according to you?
In Urban Affair Office. Your Lordship.
May I please, Your Lordship? It's just a suggestion. I'm just humbly submit that, Your Lordship. Case may be disposed of with a direct petition or may file again another representation.
Let's see, not today. We'll have after 1 week. Yeah. Today, MS as per Saji has produced instructions indicating that there is no vacant post of typist available to accommodate the petition presently. It's a matter for filing hearing after 1 week.
I'll
Much
to do.
Mr. Deb. B. Deb.
None appears for the petitioner. List after
2 weeks or 3 weeks?
2 weeks.